Hello everyone, welcome to the regular Friday afternoon Hynes webinar series. My name is Chris Hynes. I am a Strata advisor with Hynes Legal, and we typically have Frank, but we're having just a few technical issues just at the moment. So Frank should be back on screen any second. You might have noticed also, for those who regularly attend these events, bit of a different background today. That's because we're actually in Hynes Legal's offices this afternoon to attend to this and a few other bits and pieces. Here's Frank.
This is the joys of learning about technology, isn't it?
Frank.
I actually pressed a button on my phone and it killed the app. So that is my fault. That was operator error.
Never press the red button, Frank. Frank Higginson, welcome to the webinar. I was just saying to our regular viewers that we're in a slightly different locale today. We're in our offices. And it's interesting, outside, we won't risk the connection any further by getting up and showing you, but outside there is a huge bit of renovation work going on at this building. And you may hear throughout this telecast some pretty intense clanging, crashing sounds. I think you describe it, Frank.
Hammer drills, jackhammers, concrete breaking, all sorts of joy. So even if we would have been at the office, we would have had everyone unhappy being at the office because of the noise. Absolutely,
which is a very nice segue to today's topic, is it not? Welcome to everybody who are regulars and our first-timers. Hello. Please like and share this event. That'd be great if you could. You can actually ask questions live throughout today. We've actually had a few posed to us before we started, and we'll try and get to those today. And indeed, we'll try and get to as many questions as we can throughout today, because we know that, Frank, this is a bit of a hot issue, isn't it?
Yes, and I've already got people texting me to say nice shirt. So, yes, we've gone with the colours today. I know media should be clean white lines, but why not? It's a Friday. But, yeah, mate, I think in terms of issues that we get regularly inquiry about, this is right up there. And it's, hard flooring's one part of it. Pets, probably hear a siren outside there now. There's just, community living where people are living close to each other. There is going to be noise, and it can drive people to distraction.
Absolutely, it can. The prompt for this week's webinar was, in fact, a story that got published earlier this week, which came across our desks, and a pretty unpleasant one at that. So some of you might have seen this story about an incident here in Brisbane where a 70-year-old, that's 70, was given a suspended sentence for attacking his neighbour, who happened to be 63, with a cricket bat about a fight over loud music. So it just goes to show that disputes about noise and loud music are certainly not confined to young people.
No, and dare I say it, mate, not everyone likes Nana Muscuri.
This is very true. And that's a good moment to point out that we were going to have theme music today, which copyright has not enabled us to do. But for those of you who are either Public Enemy and or Anthrax fans, we were going to bring the noise today. You'll just have to hum along in the background. Anyway, back to this story. What was really interesting to us, though, was this statement from the solicitor representing the person who was convicted, and said to the court that the person had no previous criminal history and had tried to resolve the matter peacefully through the body corporate to no avail. And that actually got Frank and I very interested in this story. Look, noise isn't just about parties and loud music, and it's certainly not just about people swearing or chatting at 3 a.m. Out on the balcony with a lot of drinks. Noise and nuisance can be a few different things, can't it, Frank?
It can be. And I think, and I suppose the thing that when you found that story, it was really interesting for me. They tried to resolve it with that to no avail through the committee. Now, there's no detail there around what that actually meant. Was that a letter? Did they go through the bylaw enforcement process? Did they get dead battered by the body corporate manager or otherwise? But I suppose I looked at that, and this is, the joy of the body corporate democracy in which we live, where committees are volunteers that have put their hand up to get involved. That committee might or might not have had the right guidance around that, but it's one of those things where I look at it from a liability perspective, and the nasty lawyer in me says, what responsibility did the committee have for actually not helping to resolve that issue? Because effectively, that's what they were voted in to do. They're there to enforce bylaws. They're there to, like it or not, get involved in the management of the affairs of the body corporate and those of the owners and occupiers. So regardless of whether these people were tenants or otherwise, they've got rights, they've got obligations, and so does the committee. So, and we see that quite a bit where disputes effectively get ignored by committees, and then in effect the people are left to their own devices to resolve them, and this one resulted in obviously an act of physical violence, which maybe or maybe not could have been avoided if things had been handled a little bit differently. I don't know, but I just like the one of the warning bells in that for me was committees not ignoring these issues, because like it or not, that's what you voted in to do. If you put your hand up, it's not usually just a free-for-all, free ride, take every instruction the body corporate manager gives you and leave it out. You actually might need to do some work.
And I think that's point one out of today. There's responsibilities on both sides of this equation. Absolutely, a person should not be out there causing all manner of noise and nuisance. But the flip side, as Frank has just very correctly pointed out, the responsibility of the body corporate through its committee to do something about those issues when they occur. And look, let's be really kind of blunt about this. If you're living in a community title scheme, and again, I always say this, that word community, that's right there, it's not even front and centre, it is the very first word, literally. You're living in a community, but in particular, you're in a high density situation, you're in close proximity to each other. And while you would hope that buildings would be constructed with adequate noise proofing and you would hope that people would conduct themselves in a particular way, it's not always the case, is it? And it's very, very difficult to retrofit a building to make it noise proof, I suppose. So you've got to remember at the start, you are in an environment where noise is going to be magnified, I would suggest. You're not living in the middle of nowhere where you can turn the music up as loud as you want and no one will ever hear you because there's no one there to hear you. There's always going to be somebody else there to hear you. So with that in mind, we might start off by looking, well, what's the current legislative or legal position? There is no specific reference to noise under body corporate legislation. But Frank, it is something that's covered under a bylaw, perhaps.
Well, there is, and I suppose there's a statutory section there in terms of section 167 that says that people won't cause nuisance and that people won't interfere unreasonably with other people's use and enjoyment of their lots. So then, and I suppose probably that's the starting point. That for me is the statutory test. And what we do know is if you're really interested and want to be a sort of bush lawyer, if you want a better phrase, and go to section 180 of the Act, that's where there are limitations in relation to creation of bylaws. So the first rule of bylaws, in effect, that we always follow is that bylaws cannot be inconsistent with the Act. So the statutory test is that you can't conduct yourself in a way that interferes unreasonably with others. And to me, what follows from that is that you can conduct yourself in a way that interferes reasonably.
That's right.
With other people. So, and that I suppose is an acknowledgement of what Chris was talking about before in terms of community. The reality is there is going to be interruption. And the best analogy that I use for this all the time for clients is just, when we have phone calls about noise and interference and kids playing on driveways and whatever else it might be, what I always say to them is pretend you were living in a 300 square metre block in a house with the house next door, and what could you do about it? And the answer would be very little. So the reality is that there is always going to be some interference, but then it's a question of degree as to where that actually gets to. So there's the statutory test. On top of that, ideally, a body corporate has a bylaw that mirrors that, which then creates the ability to take a bylaw enforcement process in terms of nuisance or people that interfere unreasonably. So I think, mate, I suppose we did nuisance and challenging owners few weeks back. So there should be a bylaw there. And in that context, nuisance related to effectively communication. Probably what we're talking about today with noise is unreasonable interference, because that's really what it does come back to. And, mate, I did print out, if you were going to, because it's not on my screen at the moment, let me print out, we got to probably, you wouldn't call it the gold standard, but obviously there's been lots of disputes about noise. And I thought, just relating to people what a QCAT member has sort of dictated, which to me is the test in relation to noise and how it affects you as to whether you've actually got any actionable rights. So the ordinary and accustomed use of premises will not be considered a nuisance, even if there is some inconvenience to a neighbour. And if there is inconvenience, I mean, it does depend, as always, as lawyers say, on the individual facts and circumstances of the case, but it needs to be an inconvenience that materially interferes with the ordinary notions of a plain and sober person, and not merely the elegant or dainty habits.
Emphasis on sober.
Sober, yeah. So 3 a.m. in the morning, it's not that. And not merely the elegant or dainty habits of the complainant. So
There's
noise is going to happen.
Yes.
It's got to be something a little bit more substantial.
Yeah.
And that is where the fight starts. Because what is that?
That's
always the case.
One of the very, very typical noise disputes in a body corporate is hard flooring and the noise which gets transferred. And when you step back and think about it for a moment, it's almost inevitable that happens. If you are living in a high-rise in particular, the only way you will ever avoid it is if you are living on the very top floor, but even then you run the risk of getting noise transferred up as well. So Frank's talking there about bylaws, and what we are finding is that some schemes will put into place a bylaw specifically about hard flooring. And we'll get into best practice towards the end of today's session, but a specific bylaw about hard flooring gets very, very specific, doesn't it, Frank, and sets actual noise levels.
It does. And I suppose where you get to is there's nothing even in the Act talking about requiring owners to come back to bodies corporates to seek approval before they renovate their units, but you can create a bylaw that allows that. So that's ideally, every body corporate should have a bylaw that says before you renovate your unit, you must come to the committee and let us know what you're doing. And that then allows the committee to potentially impose reasonable conditions. So in the context of noise, particularly in high-rise, that is going to come back to acoustic underlays, types of flooring, floor coverings, all that sort of thing that take into account what needs to be taken into account for that body corporate. Now, for me, and I suppose lawyers, which is why it's interesting to me doing these things, lawyers normally sell words. We're good with words. Some lawyers aren't necessarily good with presentations, but lawyers are great at words. So when we go through and do bylaw reviews, I think probably the best hard flooring bylaw we've seen might have been a page and a half. And it went through all of the specifications and all of the LNTW ratings and FIC ratings and levels of underlay and all sorts of things. And I think the starting point for me is just because it's in a bylaw doesn't make it lawful. So bylaws, again, back to that section 180, can't be unreasonable or oppressive. So if the body corporates decided that we want a hard flooring bylaw that has the highest standards possible known to man, woman or child, and we're going to go get the Australian standards and double it, putting that in your bylaw as a condition doesn't make it enforceable.
Yeah.
So where we've really got back to now is bylaws should regulate. So before someone renovates their unit, they should come to the committee. But where we've got to is we're not trying to impose 40 million conditions in the bylaw itself with all of the detail, because they're not necessarily going to be enforceable. Because and the simple example might be you might create this rock star level of floor rating, but that won't matter for the person that's renovating their unit on the ground floor because there's no one underneath them.
That's right.
You know what I mean? So completely arbitrary rules, regulations aren't necessarily the way to go, as much as lots and lots of bylaws actually have them.
And so I think the next key learning out of today's webinar, Frank, is if you've got some noise issues at your building, get your bylaws reviewed. And importantly, get them reviewed by a lawyer. Frankly, anybody can do it themselves, but if you want to cover off what Frank has just been talking about, the enforceability and the validity of bylaws, you will need somebody with expertise to do that. And particularly when it comes to something like this, which is very specific, and you're trying to regulate a very specific thing, it's better to have somebody with expertise do that. So that's the next learning. And that leads very nicely to a question that's been posed to us. And the question is, committee has issued contravention notices to no avail. What happens next? Do you elevate to the Commissioner's office? Yes, frankly, you do.
Yep.
The question was also asked, can it be elevated to the magistrates court? Yes, it can be. If you wish, you can get a penalty through the magistrates court. How do you do that? Either instance can be initiated by the committee, but you may need to take some legal advice on at least one, if not both, of those processes.
And it's the evidence, isn't it?
Yep.
You know what I mean? This is the thing. It's sort of so easy to make these allegations of there has been noise, there has been unreasonable interference. Where's the evidence of that? That's where broad sweeping assertions never, ever work in these applications. You need detail. And ideally, you need measurements.
Absolutely. Neither Frank nor I could sit there as being tenants and say, oh, there's a lot of noise affecting me. Well, what is it? Which leads very nicely to another question, which was posed to us beforehand. In this particular situation, there was a complaint from a tenant about a noise, not being able to identify where the noise originated from, a demand made of the body corporate to find the source. Apparently, the body corporate investigated and also weren't able to identify the source or who might be responsible for it. But who would be responsible for investigating the source of noise, Frank? The body corporate or the complainant?
I think it's the complainant off the cuff. Like, it's sort of, the body corporate can't go on a witch hunt for every single time someone says something's going wrong for me, now you go fix it. And that's, it's a bit like dealing with anonymous correspondence. An example is that, well, this should stop, it should stop. But you can't actually make an application against someone unless you've got proof.
That's right.
So yes, a body corporate has an obligation to enforce bylaws, but if no one knows where the noise is coming from, which, to be honest, I suppose you'd have to geek into the circumstances about how and why. And I suppose one of the issues we have with high rises sometimes is the people on the ground floor have someone throws something over a balcony at a higher level and it finishes up on the ground floor. That's usually going to be a breach of the bylaws. Might be dangerous if it's bottled. I remember 1,000 years ago on the Gold Coast, people were throwing frozen oranges out of Q1 onto the canopy glass below and creating massive craters, which is extraordinary. But leaving aside that the behaviour is extraordinary, the issue is who did it. Because at Q1 with 80 levels, there are probably 160 potential units that could have done that. So I think, to me, it's going to come back to the complainant, because I don't think it's the responsibility of the body corporate, which effectively is the volunteer committee members, to run around and try to find a particular noise, which obviously isn't occurring all the time. They're supposed to sit there like security guards and wait for it to happen and go knock on the door.
We've got a few more questions banking up here, but before we move on from that, just want to finish off on that adjudicator's order, Frank. So the adjudicator's order that we are talking about is for Coolangatta Gold in 2018. And this order is, I think, noteworthy because in this order, the body corporate took action against the owners of the lot for noise. One of the defences put forward by the owners in this case was that, well, we're not actually doing anything differently. We're not having big parties. We're not playing noise. It's just day-to-day stuff. We're walking back and forth across the floor, nothing out of the ordinary. The adjudicator did not accept that as a defence, and more or less, and I'm paraphrasing significantly here, but more or less said, the fact that you're just doing your normal everyday stuff does not avoid your responsibilities to not create an unreasonable noise. I think that's really telling, that particular order. You can't simply state, but I'm not doing anything, I'm not holding a party. Doesn't matter. If you cause noise, you cause noise.
And mate, the other thing I think that was interesting in that one is the bylaw. There wasn't actually a bylaw requiring people to seek the approval of the committee before they renovated their unit. So these owners renovated their unit, put in vinyl flooring and the rest of it. And that was effectively what was deemed to be causing the noise. So where they got to is the adjudicator said even though they didn't have to seek approval, they've still got the obligation not to unreasonably interfere. And so therefore that must be addressed. There's a couple of ways that can be addressed. Here they are.
Yep.
You go make your choice.
Back to the adjudicator's order for a moment. Noise issues go to my former office all the time. They are a big, big issue. And the first step in those is always conciliation, because that is the best chance of getting a solution that everyone can live with. And we'll go into some best practice stuff in a moment. I think it's important to point out that if matters proceed to adjudication, adjudicators can and have done in the past order that flooring be ripped up. Now, nobody wants that because that is an incredible amount of effort time, and not to mention money. So the motivation is definitely there to try and nut out a solution before it gets to that point. I want to address a couple of questions because they're really starting to bank up. It's obviously a popular topic. Is it correct that the committee cannot enforce that a council application must be made before a renovation starts? Good question. A committee must act reasonably in everything it does. Is it reasonable to make an application to council? My question is, what would that achieve in the first place? What's the point? Is it merely making an application or making an approved application? This is where Frank's comments about words earlier really come.
Yeah, and I'd probably come back to if before someone renovates their unit, council is required to approve it, then I think it's probably reasonable for the committee to say, before you start that, we need to see evidence of the approval. But that's not just going to council. I think before you threw that stone as a committee, you'd want to be pretty sure that council did require an application, because some things don't. So and in theory, sort of renovation of a unit might be just changing the bench tops. That's a unit renovation. So from a committee perspective, what they could regulate potentially is hours of use, people not traipsing through the common property, storing rubbish out in the common property and things like that. But council's definitely not going to require an application before you remove your stone bench tops. So sort of finding that balance for me would be the tricky one there.
Okay.
And starting with council. What do they need?
Okay. A couple of questions from the same person about what about noise from dripping water through the balcony splitter pipes? It's, regardless of what the noise actually is, it's more or less the same process, which we'll go through in a moment. And then a separate question, times for practicing musical instruments in a bylaw. Is that lawful? It's not unreasonable, I don't think, Frank.
Yeah, and mate, this is where I suppose musical instruments probably is getting closer. An interesting one, the analogy that I've always used that is something that came out of your former office, Chris, is pool hours. But
this one's a bit different, Frank.
It is a bit different.
It is. So I was just going to say, I know of at least one order that's come out of my former office which enforced a noise bylaw and put restrictions on when a musical instrument could be practiced. That was in relation to, I think, a 13 or a 14-year-old who was practicing I think it might have even been the bassoon on their grandparents' balcony. So the body corporate got a successful order in that case. So it can happen, yes.
And I think probably, to me, rather than put that in a bylaw, I think that's more the committee having the ability to regulate the hours which musical instruments could be practiced, because piano is probably going to be different to bassoon, which might be different to a recorder if we're going to go back to primary school, volume and all that sort of stuff. Yeah. So I think a bylaw itself is never going to, a bylaw with all of the details of the hours is never going to give you the flexibility you probably need as a committee, because as a committee you can regulate the use of common property and lots. You can't prohibit things, but you can regulate. So that regulation making power or authority, in effect, is where you'd want to keep it, as opposed to have all of the detail in the bylaw.
I think so. Just a couple more questions, because I do want to get into the best practice stuff in the short time we have left. Question about noise being made by tenants and the real estate agent suggesting that you have to direct all complaints to the agent. No, that's not the case at all. Body corporate has and indeed is obliged to enforce bylaws directly against the tenant. Don't need to go through the agent for that. Another question, not really a question, but a statement about shift workers. And again, this is where you need to sort of know the people that you're actually living alongside. If you're in a building and there are a number of shift workers around, then you've got to take into account that there's going to be a few differences there. And again, you've got to be reasonable about it. So it's not reasonable for anyone to expect complete peace and quiet. And if somebody is working shift, then they have to drive home, park, walk up the stairs, open the door and close the door. It's about how they do all of that. If they're slamming doors and being cavalier about it, that's one thing. But if all they're doing is opening and shutting the door, it's very difficult to find some way of making them do that differently. They're finishing.
Well, and that's not unreasonable. That's not unreasonable interference. Normal use of the property. So if I'm going to golf early at 5 o'clock in the morning, the door will shut.
Yep, that's right. I want to talk about best practice now. So we've talked a little bit about these things, but I just want to consolidate it. I've got a series of steps, and some of you might have seen this in an article I've recently wrote. So hopefully it's fresh in the mind. First step, Frank, talk. Go and try and informally resolve the situation with the source of the noise. My only qualifier there, only do so if it's safe. Frank, anything to add there?
No, 100% agree. The amount of disputes, and I suppose this is part of the problem, and what we're trying to do, which is one of the reasons Chris left his former office, is trying to approach legal disputes differently. Because previously, before Chris arrived, our response to that would have been send them a bylaw enforcement notice or a nasty letter. And the amount of times that people haven't actually communicated about the issue, haven't let people know how it's affecting them, is extraordinary.
And you'd be surprised the number of times it will stop if you have that discussion.
So approach the right way.
Yes, approach the right way. So step 2, you might need to elevate it if necessary, but think about which authorities you're actually elevating it to. If the noise is in conjunction with something illegal, or if it's in the context of, say, violence or drugs, that's a police issue. That should go to the police. If there's underage drinking, for example, that's an issue for the Office of Liquor and Gaming Regulation. So take off your body corporate hat, put on a different hat. There might be other ways to resolve a noise issue.
The hat, I think, there is to pretend you're living side by side in a normal housing estate without a body corporate. What would you do? Because they're some of the alternatives then you have.
Step 3, put it in writing. But again, be specific and put it in the right way. Don't just write an anonymous note and shove it under someone's door saying, stop making noise or else. That's not going to get you a result. And in fact, if anything, that's probably going to make it worse. But be specific about it. So say to somebody, look, you're creating noise for me. In particular, I've noticed the noise is really bad between this time and this time. Could you please remember to take off your high heels when you get home late at night? That would, just a simple thing where you come up with the solution. That's a good way of going about it, I reckon. Which then leads to the next step, and it's basically you have to take some action. So you've gone through all of those previous steps. The issue remains in place. You have to decide if you're going to do something about it, and the taking of action is what's been already discussed today. The issuing of contravention notices or the initiation of a nuisance proceeding through the Commissioner's Office, the Magistrates Court, but most commonly the Commissioner's Office. As Frank has very, very correctly pointed out, you will need some evidence to make all of that stick. Otherwise, the thing will fall down. You've got to remember, Frank, I think this is a really important point. If you don't take action, nothing will change.
Yep.
Nothing will change. And the other thing you've got to balance that against, if you do take action, you're going to have to engage with this person somewhere around the building somehow. So you've got to pitch it the right way. But
DEFCON 1 from the get-go is ideally not the way to approach it.
And what you want to avoid is the situation that we started talking about right at the start. You want to avoid 2 people in the building in open conflict with each other, because that is a situation that nobody wants. And there's actually a lot of practical things that you can do about noise. There are a lot of noise dampening techniques which can be used to reduce the sound of noise. Foam, for example, placed in the right place and in the right way can make a world of difference, Frank, can't it?
Yeah, and I suppose just thinking back about that spitter pipe one before, if spitters are dripping, is there something you can put there that'll hit and soften the noise of that? Leaving aside whether that's a body corporate issue to start with, sort of just, yeah.
Rugs under tables, rugs under couches. One of the most common noise issues I think that people face on a day-to-day basis is the scraping of a chair. That's a huge issue. So again, reminding your neighbours that I can hear you when you scrape your chair, because they're going to be sitting there thinking it means nothing to them. But when you articulate what it means to you, that's where the difference lies. We've got time for a couple of quick questions. Somebody's talked to the neighbours on several occasions, sent letters to the body corporate to no avail. Contravention order was not agreed to by the body corporate. So now what? Your next option is to apply to the Commissioner's Office in that case and take the matter on yourself.
Yeah, because if a committee won't enforce bylaws, then an owner can. But they've got the same issues in terms of proof.
That's right, but you can pursue it yourself.
Yep.
Another question, what about loud conversations from people just having a chat on their backyard? These extend from 7 till 7 every day. 7 till 7 is during the day. I'm thinking, Frank, you'd be pretty hard pressed to say that it's unreasonable to have a conversation in your backyard.
Probably. Yeah, it's not, and it's probably not quite as invasive as what smoking would be. So that's the Norbury and Hogan type situation. So, yeah, people talking, I'd suspect, as I suppose Chris and I might be today, sitting there waxing lyrical about all of the body corporate issues that we deal with for 12 hours a day. I think it would be a battle to prove that that's unreasonable interference during daylight hours.
But if you are willing to keep a log and record the effect that it is having, this is the point that Frank has been articulating really well. It's all well and good to say there is a noise and I'm being affected by noise. You've got to be able to evidence it. Otherwise, your case will go nowhere at the end of the day. So you can't just stand up and say, that noise is bothering me. You need to take it a step further. That noise is bothering me. Here is the list of times. Here is how. Here is the evidence that goes with it. Otherwise, it's pointless.
And I suppose, that conversation to me, probably more than anything else, would relate back to volume. But I think going to the Commissioner's office seeking order that people stop talking in their backyard incessantly is not necessarily going to get anywhere. Unless it's offensive language, ridiculous topics, yelling abuse at each other and stuff like that.
That's a different story, definitely. We have just about come to the end today. It's clear that this is a hot topic. We might have to investigate a sequel on this one, Frank.
Mate, there's a few sequels we've got coming up, so no shortage of content.
There are a few topics that we just did not get to this afternoon, which I wanted to get to. So, yeah, stay tuned for a part 2 about noise in the not too distant future. But as Frank said, we've already got a few part 2s coming up.
Maybe we could do our own renovation rules. That would be an interesting one in itself.
Absolutely. I want to thank everybody for tuning in. We had some really good engagement today, so thank you, everybody. The reminder to register for next week's webinar will be on Facebook now, if it is not already up there, but stay tuned. Yeah. We have actually settled upon the topic for next week, Frank, haven't we? But let's not reveal it now.
Oh, no, I think if people are here and participating in this, why wouldn't we tell them?
No. Let's build up. Suffice to say that if you thought this topic was intense, next week's topic is going to be even more so. So stay tuned for that, everyone. But look, in all seriousness, really appreciate the fact that you're taking some time out of your day to tune into these events. Much appreciated. So with that,
Thank
Frank, who's doing this remotely today.
In the boardroom. Well, our noise interference wasn't working sitting in the same area, so I'm in the boardroom on my phone, hence the little technical difficulty at the start. But there you go. We're learning too.
We absolutely are. Thank you, Frank. Thank you, everyone. Thanks to the rest of the office for putting up with our noise for the last half hour or so. You can all now go back to your normal lives. Don't forget to like and share. We'll see you all next week.
Thank you, everyone.
See you later. Bye.